Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small firm in central Minnesota. What is that? That is the wrong one. Let me get there. There we go. And that's wrong, too. Hold on. Hold on. I am become boomer. Let me... Oh, my goodness. 1 second here, guys, as I have decided to ruin everything. Ruin everything. One moment while let me fix this. Let me fix this. And where are we? Oh, yeah. Here we go. So we just need that guy, and then we move that. There we are. All right. I don't know why anyone suggested that I should not do this as a live stream, but to do it as a produced video. I have no idea what you guys are talking about. There's no delay. I'll try and maybe I can clip that out of the recording. We'll do a recording for the audio later. All right, guys. Let me lay out how this is going to go. I am not going to address the chat a lot here. What I'm going to do is we're going to get started very quickly, and I am going to do the Cody Wilson defense for like an hour or so, and then we will take a break, and I will address any super chats or questions that come in once we get started. At that point, I want to have a video that is going to smoothly go through this. And I don't want it broken up a bunch because this is one, it'll help me focus through it, okay? This is kind of frustrating. It's annoying to the point, like doing this is, I'm trying to find my sheet of paper. Annoying to the point where I'm going to take even some notes as we go, maybe, if I remember to, and we'll build this out. All right, so what we're going to do as a preview, they say in your introduction, you should tell people what you're going to do, then you do it, then you conclude by telling them what you did, right? Like that's speech 101. So we're doing that. I am going to go through and pick out details first from the affidavit for the arrest warrant. Okay, details. If you don't realize what's happening here, we're constructing a defense for Cody Wilson. And I mean a legal defense, not a moral defense, not an ethical defense, not a principled stand because he's some sort of hero of a political movement. No. What we're going to do is talk about, and the reason it's Cody Wilson is because it's prominent, it's in the news now, and the case is kind of interesting. But we're going to talk about how hard it is to construct a defense where we attempt to raise reasonable doubt for someone charged with criminal sexual conduct, specifically involving a minor. It is possible to do, and there are attorneys out there who do it regularly. I do not. I do not typically do these cases. They don't come up in my jurisdiction very often, and there are guys who have been doing this for a long time. So this is how I would construct the defense. I'm not saying it's the only way to do it, but it's going to give you an idea of what it looks like to do this. It's a hard thing for attorneys to do, mainly because as a preview, you have to destroy a 16-year-old girl on the witness stand as part of the defense. And we're going to talk about how you do that. So that's what's going on here. So we're going to go through the affidavit for the arrest warrant. We're going to pick out things, the facts that we know that are important for the defense. We're going to pick out facts that we want to know that we will construct on how to ask for those things in discovery and perhaps from witnesses. We're going to pick out anomalies that we want to focus on in building this defense. Okay, so that's what's going to happen. We'll talk maybe a little bit about the federal rules of evidence because there are some things you can't do that are specific to this type of crime. And you got to work around that and find other ways to get there. All right. So we're going to go through the affidavit. Actually, I'll probably lay out just an overall strategy. We'll go through the affidavit. We'll pick out the things that are important, and then we'll start constructing it and talk about how you do it in court. And hopefully by the end of this video, we've all learned something, and that's great, me included. And we come out with some sort of idea. Let me say up front that this is a long shot defense based on what we know now. And it's a very difficult case to take. I don't know that they're going to go to trial. This is all hypothetical. So hopefully you guys find this interesting. And there will be a question time. I will clearly announce it. I will address all the super chats that come in after now. Then I'll address the first super chat in just a moment. But that we're about to get started. So at the end, maybe we'll talk about the Kavanaugh stuff. I don't want to do that, though. I want to focus on this video. So that's what we're going to do. Yeah. All right. So Bagel Goose says, I am become boomer, destroyer of... oh, hold on. Yes. Thank you. Excellent impression. Good, sir. But all right, guys. If you do have questions... save them till the question time, write them down, or if you want to send me a super chat, which of course I appreciate and very much love all of your support in doing that. If you send it, it'll be saved for you and I'll be able to pull it up when we get to those questions. But for now, I'm largely going to ignore the chat because we're going to focus on doing this and you guys are just going to kind of watch me do it live. And I think that'll be fun. I guess. All right, so I'm going to go ahead and start recording this, and that way I can segment out just this section. So here it goes. All right, so today we are constructing a defense for Cody Wilson. We are not constructing a principled defense or a moral defense for Cody Wilson. We're going to try and raise reasonable doubt to a fact finder, likely a jury. In this kind of case, you probably want a jury and not a judge. Cody does not have a strong legal defense at this point in time. Of course, that could change, but right now, based on what we know, his defense would have to be to a jury. He would have to convince a jury, basically, that a 16-year-old girl whom he allegedly paid for sexual intercourse is lying about that intercourse. So our defense is going to focus on destroying the credibility of a 16-year-old. Always fun to do. Always fun to have, a young female on the witness stand and probably a male attorney or even a female attorney who is significantly older than that person, rip them apart, expose them as a liar, or at least accuse them of being a liar over and over and trap them up on their otherwise heartfelt and sincere testimony that will be very, very persuasive. You have to do it brutally. There is no other way to do it. The other thing you have to do is you have to attack her parents. People don't like this strategy, but this is how you have to do it to raise a reasonable doubt. You have to find out why this girl would falsely accuse Cody Wilson of having sexual intercourse with her. And you have to present to the jury a reasonable basis for that assertion and perhaps an alternative set of facts to what's going on. Not alternative facts like Donald Trump, but an alternative hypothetical. You have to convince the jury that there's some other reason that these two went to a hotel on camera in Cody Wilson's car after talking online than sexual intercourse. You have to do that. It's not easy. And let me state up front, we don't have enough facts right now to do this effectively. That would be part of the process that we're going to talk about. But let's skim through this affidavit for the arrest warrant and start picking out the relevant facts. I'm not going to talk about all the surveillance stuff. We know that Cody had that Cody is identified as the person who owns a sugardaddiesmeat.com account. We know that the 16-year-old owns the corresponding account. there is something about messages being exchanged. We don't know the contents of those messages. Those messages are likely going to be presented as evidence. They should be part of the discovery file. And one of the first things we need to do is attempt to get all of the messages exchanged between Cody Wilson and the minor child. All of the messages need to be obtained by the defense as part of discovery. That, you know, you have a right to face your accuser. Cody may have copies of those messages, but we want provision of all of those messages. The other thing we definitely want, so let me write this down so I don't lose track. Messages between minor and Cody. We also need to know if this minor child had messages with anyone else on sugardaddiesmeet.com. We would want to ask for messages from any other social media networking sites. I don't know how much of that we'd be able to get, but we would be looking to subpoena, we'd flat out request access to all of the messages between her and anyone else on Sugar Daddy's Meet. And then if Cody talked to her on any other platforms, we would request messages from any of those other platforms as well. So specifically focusing on messages between the minor child and other adult men. And one other person that is in particular curious would be the female friend. I believe it was a female friend. I don't know if it actually says. Who, this is not in the arrest affidavit. This is a news story later. There is a friend who allegedly tipped Cody Wilson off about the upcoming charges, either right before his Taiwan trip or after he arrived in Taiwan. We want to know about the messages between the minor and her friend. That detail has one that has stuck out from me, from the beginning. I have no idea why you're on Sugar Daddy's Meet having a one-time meet liaison with a minor child, and when you're about to be charged with arrest for sexual contact with that child, that the friend of this person alerts you to that fact. Very strange. It's just unclear to me why he has contact with a friend, why that friend would reach out. It's weird because the whole idea of something like Sugar Daddy's Meet is anonymity. You meet someone you don't have access to, right? Like it's bringing two people together. Same with any dating site, for example. So that is very important. Now, we would also want any email messages relating to from the minor child to Sugar Daddy's Meet, confirmations about anything. Basically, we need to know. Let's see. We need to know how long she's been using this service. We need to know if there are any other men involved. We need to know if this is a common thing. Now, this will get very complicated. All right. The complication it lies in Federal Rule of Evidence 412, I believe. Now, the states have their own rules of evidence, but they follow the Federal Rules of Evidence basically verbatim. So Rule of Evidence 412 is specifically you cannot address the sexual proclivity of a victim outside of very limited circumstances, okay? Of a victim of sexual assault. All right. So what Cody cannot do is try and present evidence that this girl sleeps with a bunch of men, and that because that would be more prejudicial to her than it would be probative of whether or not he engaged in sexual intercourse with her on this particular occasion. All right, that'd be trying to use the left's word, slut shame her, in essence. It would say, well, this girl sleeps around with all sorts of guys. That's not an excuse. That's not a defense to this crime. It's not a defense to any sexual assault crime at all. And so that's why it's excluded. The exceptions to that rule would be if they, not involving a minor, typically, had an ongoing sexual relationship. It could be used to basically build almost an implied consent. Like if it's a couple that has sexual intercourse with frequency, then it might be reasonable for a person to think that they don't need as explicit of consent for this particular encounter, right? If they've been having sex for 10 days straight, and then this one particular encounter isn't really evidence of a rape in that context. It doesn't mean it's not. It just means that you can start to raise that as a defense if you have an ongoing relationship. Probably not at play here. We have to tread very, very carefully about accusing a 16-year-old girl of being a slut through her sexual activity. Not a good tact with the jury, and also unacceptable under the rules. All right. So the next thing we want to do is, let's see. So let's go through this. Counselor. So this is where I want to start picking things out of the affidavit. On August 22nd, 2018, officers with the Austin Police Department responded to a call for service from a counselor who stated that a client, a juvenile female under the age of 17, advised her she had sex with a 30-year-old male on August 15th, 2018, was paid $500. Okay. So they received the report and scheduled a forensic interview. August 27th, 2018, your affiant attended the forensic interview, which was conducted by Grace Moon, certified forensic interviewer employed by the Center for Child Protection, juvenile female who is fully identified in the report, and hereafter will be referred to as victim, told the forensic interviewer she had sex with a 30-year-old male at a hotel in Austin, Texas, and was paid $500 by him. Here's the question. Why is she at the counselor? Okay. This is... And we can't ask the counselor as easily. You can actually, it's not true. Like doctor-patient privilege does not necessarily extend to trial. Although there is a privilege there, it can be overcome. In this case, I'm not sure if we can overcome it as it is a victim. But what we can do is try and find out not what was said and exchanged between the child and the counselor, right? That's not the goal here anyway. The goal is to find out why the child is at a counselor in the first place, and stick with me on this because this is going to go to the parents and how we start constructing that defense. Why is child at counselor? Sorry, when I say something that doesn't seem to fit, it's when I'm writing it down. I'm just talking out loud as I write. So they go through this. Here it says the victim's parents consented for the Austin Police Department to search the victim's phone. They searched the victim's cellular phone and discovered 2 hyperlinked messages to sugardaddymeet.com. There's Sanjuro, and this indicates the message connected to the hyperlink was sent between the victim and Sanjuro. Great. During this conversation. So I guess it's just 2 messages, but I think maybe there was potentially some other alternative conversation. Oh yes. Victim stated that she and Sanjuro continued to text via Apple iMessage. So as stated before, we're really going to want to know what all of those messages are, both on Sugar Daddy's Meet and on Apple iMessage. And we're going to want to know if there are anyone else that she contacted on Sugar Daddy's Meet, any other profiles that she spoke to. We don't really need to bring those other profiles in. We just need to know for this defense if she spoke to other men on this platform, if she spoke to other men via Apple iMessage, or women, I guess, technically, but we're probably looking for men. And we just need to know what the nature of those conversations were. Okay, so then we know that they went to the hotel. We know we have surveillance. Like, One thing they could try, I mean, they could try and suppress any of this evidence. I don't see any grounds for suppressing the evidence. What you would have to do is allege some sort of Fourth Amendment violation. But all of the surveillance footage has been apparently willfully provided by third parties. So they didn't like take Cody Wilson's stuff to surveil him. They got it by asking. So that's fine. He has no expectation of privacy in the surveillance footage of a private business. So that's going to be really hard to go after. They also have, you know, a counselor who is a mandated reporter reporting about the potential sexual abuse of a child, and that child coming in and offering testimony of her own free will and consenting to searches. Cody doesn't have an expectation of privacy in any of that stuff. They did not apparently search his stuff. It is entirely possible, if we want to go, we're not going to get into this, but if you want to go with like a deep state conspiracy theory, considering the fact that he is fighting 22 attorneys general, there is a possibility that he was being monitored. Plus, we know that part of that monitoring would not be that far-fetched, as his business relates to potentially and allegedly, according to an ongoing federal investigation, which was resumed under court order, that he is exporting protected data in violation of U.S. customs laws to foreign entities. That puts him in the realm, in the ballpark of something like FISA or other types of surveillance. They now have a potential cause. I'm not saying they did that. That's going down a road with no facts that we have. And that would be, someone has asked about parallel construction. That would potentially be this idea of parallel construction, where they found information about Cody Wilson by illegally surveilling him, allegedly, and then attempted to build a case in a roundabout manner from that. Like they, I don't know, induce this girl to go to the counselor or something. But we're talking deep level conspiracy. It's not really going to be effective defense without some serious facts. And even then, you're talking about conspiracy that goes beyond probably what you're able to fight. So let's move on. Let's move on from that. Okay, so they went to the Archer Hotel. There's surveillance footage on them apparently getting out of the car at the valet, walking through the hotel lobby, going up the elevator, going into the room. Now, here's where the crux of Cody's defense lies. The crux of Cody's defense is, I did not have sexual relations with that woman. Not one time. Didn't do it. Right? Like he's got the Bill Clinton defense. He did not do it. The state has to prove beyond a reasonable doubt that Cody Wilson caused the penetration of the anus or the sex organ of this minor child. Has to prove that beyond a reasonable doubt. As far as they have alleged in this affidavit, there is no forensic physical proof. Like they were not, according to this, that may be there may be a lab somewhere, but they did not recover like semen or pubic hairs or something like that from the minor child. So this was apparently, you know, obviously the allegation is that she went to her counselor quite a time later and then reported about a previous act. So I'm going under the assumption that there is no physical evidence recovered from the victim. All right. So as far as we know, they only have the victim's statement that she had sexual intercourse with Cody Wilson. That is the sole grounds for this charge. Let me be clear. That is a sufficient grounds for the charge, because then if he says no, no, I didn't, then you have two people who go before a fact finder. This is the job of the jury. Something you always need to remember. The job of a jury and a judge is to find the facts that are most likely to be true. Okay? Not to render guilt or innocence. That's not their job. Their job is to lay out under law what the factual record states. And then it's a matter of application of the law to the set of facts that the judge or jury has determined to be the truth, or the best truth. Okay? So in this case, hypothetically, we have a teenage girl saying we had sexual intercourse. We have a 30-year-old man saying we did not. They would both go up potentially and testify. Since there are no other witnesses, ignoring any other strategy, the he said, she said strategy would require Cody to go on the stand. Not always the best plan to have someone go on the stand in their own defense. Maybe they're good, maybe they're not. That's a decision for Cody and his attorneys, obviously, on if that would happen or not. But you're not required to take your own defense because the state is required to prove your guilt, not you prove your innocence. Although it doesn't look like that most of the time. All of that said, it's his word versus her word. So if they're alleging that they did not have sexual intercourse, or that the state needs to prove that they had sexual intercourse, the girl is going to go up on stand under oath, and she's going to, probably with tears in her eyes, talk about this damaging sexual encounter that they had. And she's going to be very believable to a jury because she's a child, and what reason would they have to lie? And that's not a criticism of the child or of the jury. That's just the reality of how the perception goes. So how do you fight that? One, you can have Cody Wilson take the stand, take his own defense. Iffy on if you want to do that. Best thing to do would be to take the only credible witness and paint her as a liar. That's honestly, in my opinion, your best strategy based on the information we have now, to paint this girl as a liar, and then to support that by making her parents seem reactionary, overbearing, and unreasonable, and basically forcing this narrative. Okay, so here's how we go about it. All right, so there's the way exam and cross-exam works is a dance. All right, so the prosecution is going to call these witnesses for exam or cross-exam, or for exam. They're going to call witnesses in support of their case for examination. All right, and then when you're on examination, when you're on the primary examination with a friendly witness, you have to ask open-ended questions, not leading questions, and you have to let them tell the story. All right. So a prosecutor will get this girl on the stand. He will say, tell me who you are. What's your name? What high school do you go to? Do you go to dances? All that stuff. And they'll lay a foundation for that this girl is a minor and that she's normally engaged in the activities of a normal minor. That's how they're going to lay it out. Then they're going to ask her to tell them about her interactions with Cody Wilson on Sugar Daddy's Meat. They're probably not going to talk very broadly about Sugar Daddy's Meat. They don't want to, in my opinion, the prosecution would not want to let on that this girl has had multiple interactions. And I don't know that she has. But I have a feeling that Cody Wilson is not the first person and only person that she talked to on Sugar Daddy's Meat or some comparable website. I have a feeling that it's not, especially because it's 2 messages there, straight to iMessage, and then into a hotel. And what was that timeline? Let's see. Oh, that timeline isn't in the police report. We just know that they met on August 15th. We don't have the timestamps and date stamps listed in this affidavit from the messages that were sent. So we don't know how long they were messaging prior to this meetup. I don't want to speculate. But my spidey sense tingles and says this is probably not the first and only time that this girl has done this. Maybe it is. Maybe it's not. I don't think so. And we're going to go with that hypothetical for now because I don't have a way to find that fact at present. And we may never know. Because this is a minor, a lot of the stuff about the minor is going to be sealed, and it will not be accessible to the general public. That's the way it goes. All right. So, so we're going to want to lay out the idea that this girl has had other conversations with other men. Potentially, we're going to hint at the idea that she has had sexual intercourse with other men who are over 18 from Sugar Daddy's Meet or some other hookup website, maybe Tinder. Maybe something as basic as Tinder, but maybe something more elaborate where a payment scheme is involved. All right. And then what we're going to, the strategy would be to basically tell this story. All right. Let me tell you a story. So this girl goes, she has sexual intercourse with Cody Wilson, or maybe not. No, I'm already destroying my own story. Let me start over. So this girl goes, she meets Cody Wilson on SugarDaddy'sMeet.com. All right. Cody is under the obvious assumption that she is 18. This of course could be destroyed by the messages that are involved. We don't know the contents of those messages. If this girl said, lol, I'm actually 16 and super hot, Cody's done. He's done. Absolutely. And he should be, under Texas law, done at that point. All right. So if that's in the messages, then you can throw all of this out. We don't have any indication that that's there. And I think that type of message would be included in the arrest affidavit if it were there. I think it would personally, but I don't know. So if that message is there, I think we would see it. It's not, so I'm going to assume it's not there, and that Cody Wilson was under the assumption that this girl was at least 18 because Sugar Daddy's Meet requires you to affirm that you are 18 years of age or older. So Cody picks her up at the coffee house as stated. They go back to the hotel room for some Netflix and chill or whatever they're going to do. Mind you, the Sugar Daddy's Meet website and other websites like it fly under the radar of prostitution because you're not exchanging money for sexual encounters. You're exchanging money for the time and company of a particular person, an escort, if you will, and there is no contractual obligation or promise for sexual activity. That's how these websites stay in business and remain legal in a country where prostitution is largely illegal. And yes, the age of consent in Texas, I'm not supposed to interact with the chat, but this is a good point. The age of consent in Texas is 17. I'm going with 18. One, because I don't know that Cody Wilson knows the age of consent is 17. And two, on Sugar Daddy's Meet, you affirm that you are 18 years old. So that's why I keep saying that Cody, and again, I don't know what Cody's actual state of mind is, right? I'm constructing a defense and telling a narrative story of how you construct this defense. The narrative story, and trust me, 18 will play better with a jury than 17. Hold on, the stream is back. Okay. So I do understand that 17 would be okay. 18 will play better because your average person believes that 18 is the age of consent everywhere. I'm making a blanket assertion, but that's kind of a common thought in the U.S. And then again, the website says I'm 18 years of age or older. So Cody Wilson believes this girl is 18 years old. They go back to the hotel room. Cody finds out. This is the narrative again. Remember, Cody finds out that this girl is not actually 18 years old. And he says, whoa, wait a minute. I'm sorry. I can't be involved with someone who's not 18 years old. That is, one, that's against the law. Two, I'm fighting a whole bunch of attorneys general because I'm, quote, kind of a big deal, right? This girl alleges that she had done some research on Cody after he said he was kind of a big deal. So she knows who he is. He explains, look, I can't be involved in that. I'm sorry for wasting your time. Here's the $500 we agreed to for the date. I'm going to drop you off. Where do you want to go? Drops her off at Whataburger. And then that's it. That's the narrative story of Cody's night with this girl. They had a nice time. Things were leading up to it. Lets out that she's 16, or he starts to get the impression that she's 16, confirms that she is too young, and then shuts it down. Shuts it down, gets the $500, gives it to her, takes her to Whataburger, and is done. Peace out. Cody Wilson is out of this story at that point. No sexual intercourse occurred. You can't prove that it occurred. That's what happened. So then, why is this girl lying to everybody else? Why is she asserting that Cody Wilson had sexual intercourse with her? Why does he need to go to jail? Why would she do that? And this is where you start to, this would be highly dependent. I should say your approach to this would be highly dependent on how you get, how the regular examination of this girl goes from the prosecution. So the prosecutor has a very open-ended approach to her telling the story of what happened, right? And then when the defense gets to cross-examine, they're not bound by the same rules. They can lead the witness. They can put words in the witness's mouth. They can demand that the witness be restricted to yes or no questions, and they should. You should never let a witness on cross-exam, you should never let them tell the story. Yes or no. Isn't it true that this? Isn't it true that that? You very much restrict their ability to speak, because on cross-exam, you're telling the story that you want the jury to hear. You're not letting them tell the story, because obviously they're on the side of the prosecution. Okay, so what you'd have to do is pick parts of the examination testimony, and you'd have to start piecing this narrative into it on cross, implementing facts about it. Isn't it true that Cody Wilson picked you up? Isn't it true that you clicked agree that you are over 18 on the website? Yeah, but answer the question. Isn't it true that you clicked agree that you're over 18 on the website? Yes. Isn't it true that on this website you must be over 18 to participate? Yes. Isn't it true that Cody Wilson picked you up? Yes. Isn't it true that in your messages to Cody Wilson you never discussed your age, or you affirmed that you were 18, whichever one it may be? Yes. All right. Now, isn't it true that when you got to the hotel room, you and Cody started to engage in some activity, and he decided that this should not proceed? No. But isn't it true that you let him know that you were 16 or something like that, right? And maybe she admits during her testimony that she talks about being 16, okay? But that's how you have to tell the story. You have to drive the narrative through it. So that's where you're going to start hammering on this. Now, the other thing, like I said, that you want to do is you want to get the tweets, or not the tweets, the private messages, and you want those private messages to be introduced as part of the record. You want to start asking her questions about those private messages, because that's going to be another important part. I am still operating under the assumption that this girl has done this with other people. Okay? Now, and when I say done this, I don't mean she has had sexual intercourse, right? I mean she has messaged and attempted to quote unquote catfish someone through these services. All right, she's engaged in messaging with men over the age of 18 in an attempt to get money from Sugar Daddy's meat, right? Like, that's the whole point of the website, is for wealthy men to buy dates from less wealthy women. Euphemisms. All right. So, the next story, again, how do we get to why she's lying? So this is going to involve testimony from the parents. I am operating under another assumption here. My assumption is that this girl went to counseling because her parents became aware of her activity one way or another. All right? Either this girl admitted it to him, they checked her phone, They checked her location, some sort of location tracking software through like Verizon, for example. My guess is that the parents discovered this activity and wanted her to talk to somebody about it. That's why I think she's in counseling. I don't know, but she is in counseling. So she got there somehow. And usually, I think kids are not like, you know what I need? I need to go to counseling as a minor, right? That some kids do for sure, but I don't think that's typical. So I want to know the story of how she went, why she's in counseling in the first place. Again, I don't care. I don't care that she's in what is said in the counseling session. That would be really difficult to get out. And I don't think that's that important. What I do think is important is why she's in counseling, how long she's been going to counseling. And you can frankly ask her. That's the beauty of cross-exam. And it is relevant, I would say, how long she's been in counseling and what for. Why are you in counseling? What sort of issues? If you don't ask her, you get her to admit that her parents suggested her going to counseling, because I think that's the likely outcome, is that her parents said, look, we noticed some activity that we didn't approve of. Well, what kind of activity? When did you recommend she go to counseling? How many times have you taken her to counseling? You go ahead and start laying those things out and building the story that the parents found out about this activity, maybe not with Cody specifically, but with various people, that she was engaged in these types of activities. They were worried about it escalating. Maybe Cody was the first date she went on. Absolutely could be. But if they checked her phone after she went on this date and was gone for several hours and they didn't know where she was, they checked her location data. This is, again, I'm speculating, but they checked her location data, found out she was at a hotel. Very strange, only for like 2 hours and then she leaves. So then, they start to ask questions, check out who she's been messaging, what apps she's been using, find the sugar daddy's meat thing. All right. How long has it been going on? Then they start researching. They check through her messages. They find all the messages between her and other men, even if it didn't work out. And now she has gone on a date. Now things have escalated to the point where she's potentially in danger. And these parents are perfectly reasonable at that point, suggesting she goes to some sort of counseling, right? Or getting some sort of help, figuring out what's going on there. There's not a clear story between her and her parents, because this is not typical behavior of a minor child. And you have to remind the jury of that. You have to. You have to talk about the fact that this is atypical for a child to engage in this sort of thing. The parents being involved in this whole sort of thing is going to be emotionally damaging to the parents. I would hope. If not, maybe that's better for Cody's case. I don't think so. But if it's emotionally damaging to the parents, you have leverage at that point to start getting them on the witness stand to start talking about their concerns about their daughter. Of course you're concerned. You have concerns about the safety of your daughter, right? Obviously. Isn't it true that if she went on a date with a 30-year-old man without your knowledge, you'd be concerned about it? Yes. Well, isn't it true that you discovered that she was going on these dates and you confronted her on it? Yes. Isn't it true you had an argument? Because that's the reasonable assumption, right? That they had an argument. So you start building this story that there's friction between a daughter who's going on a prostitution-style website and seeking out older men and reasonable parents. You set that up. Go ahead and hammer that all day if you want. And really hammer on that with the parents, because you need to break them down. And this is the uncomfortable part. You need to break down the parents. You need to break down the daughter. And you need to break down that relationship between them. Okay? You just have to if you're raising an effective defense. Especially if it's true. Then you really have to. You really have to. So you got to wear them down, and you've got to get them on stand to start making admissions that go along with your story. That goes along with your story. And getting that story to the jury. So she started doing this maybe 3-4 months ago. Her parents maybe noticed it. I don't know. Maybe that comes out that they noticed it before. They asked her to stop. She didn't stop. They thought she did, but she didn't. She hid her activity. Then suddenly she's gone for an entire evening without their knowledge, or she said she was going somewhere else and turns out she wasn't there. Again, if this activity is known to the parents or even suspected by the parents, they're going to be looking for her. They're going to be looking out for her safety. I would think. The other tack you could go is like they induced her to do this. I don't think that's a safe attack. That's like what, Wrong Way by Sublime. Anyway, so you start building that friction between them. You start building a plausible reason why these parents are trying to find out about their daughter's activity while they're having this friction between them. And you give her the rebellious excuse to go try and earn some money with older men on some harmless dates, right? Some harmless dates over the internet. So you build that story up. Then finally, I mean, where you have to draw this in is you have to come to the idea that the parents freaked out and she said, yeah, I'm definitely going to stop because the guy had sex with me and I'm really broken now and now I need help and now I need to stop. Right? That's what it's going to come down to. That's what it's going to come down to is that you get them and her to admit to this idea that her date with Cody was the straw that broke the camel's back on this dangerous activity. Now she's going to allege they have sex. She's going to allege that she's damaged. You're going to set her up as someone who does this all the time, that this is not new. And you're going to do it, of course, without stating that she engaged in any sort of sexual activity with any other men than Cody Wilson, because you can't do that, right? You can't bring that up. That's not like I said, that evidence will be thrown out. That testimony will be stricken from the record. So you're going to have to go through and set it up that she was engaged in this behavior with frequency, that she typically, it might even be better if she did not have sex with other men, but when her parents found out that this is the activity she was engaged in, that they freaked out on her, and she used the sex with Cody Wilson as a deflection to her otherwise bad behavior, to her otherwise failing relationship with her parents, to her otherwise affinity for catfishing older men for money, right? That's how you have to do it. That's what the defense looks like, in my opinion, based on the facts that we have here and facts that I think we're likely to come across. Those facts, of course, being contact with other men, those facts being messages between, and of course you have the friend who alerted Cody Wilson. Sorry, I looked down at my notes and I found out that I had a note for the minor and her friend who alerted Cody Wilson of the impending charges. The friend doesn't make sense. The friend is sympathetic to Cody, I would think. Maybe the friend called up and was like, hey, dirtbag, you're going down because the cops are onto you, sucker, or whatever the kids say these days. I don't know. Maybe that's what happened. Or maybe it was like, hey, so-and-so feels really bad, but she had to tell the authorities that she had to tell her counselor that she had sex with you because her parents were on her back, and turns out they're going to come after you now. So I know you got a lot of money and stuff or something. Maybe you should flee the country because you're kind of a big deal. Or maybe you should get away or get out of here. Or just know that they're coming for you. Why is this friend... I cannot imagine how he knows her. Why, or him or her. Why is this friend sympathetic to Cody Wilson? That's a huge, huge question. That's the wild card, I think. But if that friend is sympathetic, you can get that friend to, or you can force that friend to testify about knowing about this activity with the victim, about knowing about the victim's relationship with the parents, And maybe this is how you actually get to some of those things from a foundational perspective, because for any of these questions that you're asking, they have to be relevant to the case and they have to have some sort of foundation. You can't just ask a question out of the blue. You got to build your way to it, either based on something they said or some fact that you've established somewhere else. All right. So you can get the friend to start to testify, not about their opinion of the relationship with the parents. Just get the friend to testify about all the times that the minor child complained to her or complained to the friend about the parents and complained about the relationship and how she talked about doing these things and how she talked about dating older guys. That's what you do. You get those things and you start to raise that doubt that, oh, this happened. And you say, you get her to testify either about sexual activity with other men or not. You get her to do it though, not to and you don't ask about it. You've got to induce her to say these things kind of craftily, but you don't do it to the main victim, right? So you have to set these things up in this way. There are some clues, and this is what I want to point out. There are clues that lead to the possibility of a defense, even though it's a tough long shot for Cody Wilson. But the hardest thing to consider is that maybe this story is what happened. All right? Maybe Cody went on an encounter thinking this girl was 18 years old, found out she was not 18 years old, ended the date, gave her $500 to shut her stupid mouth and not say anything because he knows exactly how this looks. Knows exactly how this looks. I'm not going to say anything about his personal tastes, but what has been demonstrated over and over and over is that Cody Wilson is not a stupid guy, and he's not a guy who is unaware of legal realities, and he's not unaware that the government is after him. So, maybe he likes young prostitutes, all right? But it's entirely possible that Cody Wilson doesn't like young prostitutes. He just likes prostitutes and had no intention, once he found out how young this person was, of having sex with them. That is entirely possible. I don't know. But that's the type of narrative you want to build. Either that, Cody is a high-profile figure. He was looking for a quick relationship or a quick encounter with someone, found out that they were too young, tried to break it off, gave her some money to keep her quiet and for her time, as they agreed on the sugar daddy's meat thing and the Apple messages, and then drove her home. And then all of this is a product of her failing relationship with her parents, her spiral into increasingly dangerous activity, and her proclivity for having encounters with older men, of sexual or not sexual, but increasing. You'd want to kind of lay out the idea that they were increasing in danger to the minor child. So that is how I would construct a defense for Cody Wilson based on what we have now. I'm going to take a pause and open to questions, and I'm going to read the super chats that have come in during this time. So if you have any questions about this or thoughts or ideas, please send them to me and I will start addressing them. But if you're looking for just my initial thoughts on how you build a defense, this is how, in my opinion, based on what we have, you build the most effective defense available. Hopefully, more information will come out that will either annihilate my theories and my hypotheticals or reinforce them, and we'll be able to address that as it goes. But for now, let me hit the super chats real quick and see what's going on. Doug Wade says, "You're okay for a boomer." Thank you, Doug. I appreciate that. Stephen Severin says, "I bet she went to counseling for her to get the attention since Cody is a big deal." It's entirely possible. And Stephen Severin then says, "I'd build her as an attention whore." And that is a valid approach. Although I would suggest that her being an attention whore, if she had sex with him, doesn't change the guilt of Cody Wilson. So you'd want to tread carefully on that. But you could certainly say that she constructed it as an attention whore. And that would be another fact to get to with the friend. If the friend could provide examples of her being untruthful or exaggerating facts or things like that for the purpose of becoming more popular or getting attention, then you'd certainly want to focus on those things. But you have to be very careful with how you establish the character of another person. There are federal rules against going just straight to the character, although I think victim accuser's character is in play. Let me look real quick. There may be an exception in criminal trials. So while that, what if the girl refuses to testify? If the girl refuses to testify, the police have no case. They're going to have to get her on the stand. They have no alternative physical evidence. They have no witnesses to the crime. All they have is her statements to law enforcement. And if she's not willing to go on the stand and testify, then you get to run roughshod over that prosecution. You really do. So don't, that is certainly a possibility that she's unwilling to testify, but the prosecution is going to need her to testify for their case. And if she doesn't, they're going to come with a really friendly plea deal for Cody Wilson, or they're going to potentially have to drop the charges. Let me see. Okay. Okay, so yes, you can actually, Rule 608, this is for a witness, all right? Let me just read the rule. Reputation or opinion evidence. And this is the good thing about having a potentially friendly to Cody Wilson friend who is willing to alert him that a criminal case is coming. A witness's credibility may be attacked or supported by testimony about the witness's reputation for having a character for truthfulness or untruthfulness, or by testimony in the form of an opinion about that character. But evidence of truthful character is admissible only after the witness's character for truthfulness has been attacked. So, since this is a witness and you're going to call the witness untruthful, you can attempt to, through the parents and through the friend, you can attempt to construct this idea that she is not truthful, that she is that she has a habit of lying, that she's lied in specific instances, and she has a reputation for being untruthful. One other thing to do would be to try and talk to some of her friends and get statements about it, anyone who might have information about this. So I'm going to go back and start addressing some of these tags. Avoiding the joke ones for now. Let's see. I addressed the keep saying 18 one. Okay, Andrew Gluck asks, if you have to declare that being 18 is what you are, could the girl be guilty of deception? I mean, she's guilty of deception in some way, but that's not a crime. Deceiving people is not a crime. And no, she's there's no defense that a minor lied about their age. Okay. Ryan English says, how do you come across as more sympathetic than a crying 16-year-old girl? You make her unsympathetic. That's the unfortunate truth. That's why it's an uncomfortable defense. You really have to aggressively attack her character, and start breaking down her story. Ryan English then says, sorry you lost me. How does pointing out other times she had sex with older guys help Cody argue that he didn't have sex with her? It doesn't specifically help. What ideally she would not have had sex with a bunch of other men, for example. But if she did, you could go with various avenues off of that. And again, you'll have to take some of this information that you may not have until testimony occurs. But if you find out that she was having sex with other men or she testifies to it, the question becomes, did Cody find out about it? Did she talk about this? Did they exchange messages about her doing this? You know, this isn't her first time doing this, all that stuff. And then you build up the idea that he thought that she was 18 and then found out that she was a minor who had catfished other guys, I would suppose. But again, it's going to really depend on what that looks like based on those messages. And I don't know. So that's tough. Let's see. But is the other older men question the Kobe Bryant defense? I don't know. What's the Kobe Bryant defense? Is it that she was having sex with everybody? She's a hoe? Is that the defense? That defense doesn't work. Like I said, the idea of her having sex with other men is a complicating factor more than a beneficial factor. So I want to make that clear. It's a tough road. What is the purpose of grilling her parents? You want her parents frustrated, all right? Because you want her parents in the state of mind in the courtroom that they are in conflict with her, because you want that to come through to the jury, all right? So you want the parents to talk about the frustrating behavior that they've been witnessing. You want the parents to, because you want the parents to become more and more like monsters, all right? That this girl is having to come up with a story to deflect their ire from, without calling them monsters. You want that frustration and conflict to come through. Again, this is all my opinion. You want that frustration and conflict to come through because you want the girl to have to come up with an excuse for her behavior, or to come up with some reason why things are now going to change, some reason to appease her parents or deflect her behavior from them. All right. So that's why you want to grill the parents. You want the parents into an agitated state with her, and play on the fact that they knew about some of this going on, and that they pressured her into doing this. Two, that she was acting out against them in maybe an increasing way based on their declining relationship, and that she was ideally, if you could convince the jury that she lied about the sexual activity because the sexual activity was worse than what she was doing, and she did it because of the declining relationship and to maybe lash out and hurt them, that she lied about what happened, that would be a great thing to do if you could convince the jury of that. And if you've never seen a child lie about doing something worse to kind of get back at their parents, let me tell you, that does happen with some regularity. It was said that the woman that Kobe allegedly raped had had rough sex with other men. No, I mean, that defense is not applicable here. Contrarian 420 says, isn't it also suspicious if he was the only person she interacted with on the site? Yes. And that would be, I think, I don't want to construct a defense that way, because I just doubt it. I'm not even saying that this girl was out having sex with people, but I think she might have been toying with the idea of going on dates for money. I mean, heck, I don't remember when exactly. I could look it up real quick, I suppose. Let me see. NPR, sugar daddies meet. I thought there was an NPR story, but I don't have the don't have a direct link to it. But I believe maybe it wasn't NPR, but there are news stories about these websites and girls paying for their paying for college through these dates with other men, and they had interviews with it. Sugar daddies meet. Gosh, I wish I had the link to that website right now. But anyway, so there was a news story out there where girls were using this as a tool to earn money, to pay their way through college. I think she might have been toying around with it. That's the feeling that I get, toying around with the idea of finding a way to earn some extra cash. She's 16 years old. She can work or she can go on dates with exciting and dangerous rich men. Ryan English, what might a plea bargain look like in this case? In this case, because it's Cody Wilson and because the nature of meeting her online, I think a plea bargain comes with minimal jail time. Maybe if he's pleading to it, I think 2 to 5 years probably in prison, and a restriction on internet communications. I think that's a big one. Monitored internet communications and heavily restricted internet communications, restricting access to things like social media. Mainly because the cynic in me says they want to shut Cody Wilson's voice down, even though he's no longer the official representative of Defense Distributed. Of course, that would also include a large amount of probation time, probably the nature of 10 years of probation if they're doing a short sentence on prison. And then I think the sentence guidelines are 2 to 20 years. I don't know in Texas if they can go below 2 years. But I think registration on the sex offender registry, probably for life. I think like a 2 to 5 year prison term, and then restricted internet communications and like 10 years of probation, monitored probation would be what he'd be looking at. Maybe he gets something less. It really does depend on what evidence the prosecution actually can present, how credible they think their witness is, and what contrary evidence exists. I mean, if the defense asks for messages for her, for access to her phone and gets all of her messages, and there's a whole bunch of other men on there that she's been trying to catfish, like it or not, that's going to mess with her credibility in general. Because even if you don't allege sexual activity, that's going to look bad to a jury, and the defense is going to hammer on it. So it kind of depends on what they've got, but that's my thought. Is there a scenario where Cody could get convicted of something, but not a felony, or only a conditional felony, so he could still work with guns later? No. In this case, I don't think so. I don't know what offense they would have him plead down to, because if he didn't have sex with this girl, and they can't prove that, and they want him to plead down to something else, I don't know what crime they have him plead to. That's the tough part. So, yeah. And Drudge Steam says, Jesus, all that because she was 16, the States is crazy. Yes, in many European countries, what Cody Wilson did would be completely legal, as she would be within the age of consent. European, South American, Asian countries, a lot of them have an age of consent of 16. So, the case alleges exchange of naked pictures. Correct. I don't know. He's not charged with possession or distribution of child pornography. So it depends on the content of those naked pictures. In a weird way, it is theoretically possible for a nude picture of a minor to not be child pornography if the minor is not displayed in a lewd or lascivious manner. So if they're not being sexualized, but they are just nude pictures, it is possible to argue that they are not child pornography, and they are not, or that they have an artistic purpose, for example. So think of a photo shoot of a nude you might find in Vanity Fair. It also depends she could send a nude photo that does not display her breasts or genitalia, and that might be okay, even though it's a minor. So it really, the context of the picture can actually matter if you're making a legal argument for what is or isn't a piece of child pornography. And the state not having charged him with that might be afraid that the picture doesn't measure up. It might play very well that it's a nude. People can take nude photos and not actually be exposing themselves in those nude photos. And maybe that's what they exchanged. Who knows? Who knows? That's a tough one. But if that were the case, that would still be a felony. And if they arrange some sort of plea deal for that, it wouldn't really help him in any sort of way. Could he be charged for solicitation? I think they would have if they thought they could win. How's that? I guess in theory he could, but they didn't charge him with solicitation. So I am thinking that all of the messages and communications they have regarding payment, if any messages involve payment at all, that they are couched in the idea that they're paying for, or that he is paying for her company, her time, and a dating experience, and not sexual intercourse. So I think in that case, if they were going to charge him with solicitation, I think they would. I don't think they have a case for it. Zephael says, if you were defending someone and possible child pornography was involved in that case, can you legally possess it? No, not really. I believe to examine that evidence, I would have to go to the agency that was holding on to it and have a viewing time, which I would not want to be involved in that case. Let's put it that way. I don't want to deal with that. I don't want that darkness in my life in any sort of way. So, no. Possession of child pornography is a strict liability crime. And it's one of the few instances where lawyers can actually get in trouble. So, weird story, or not weird story, but weird hypothetical. Someone walks into your office with a bloody knife that they just used to murder someone and says, I just stabbed this guy. Can you hold the knife? And you're their lawyer. Yeah, you can hold the knife. Do you have any duty to disclose that to prosecutors? No. Because you do not think that knife will be used in an upcoming crime. You can't conceal it from prosecutors if they have, reasonable belief that it's in your office, or the guy testifies about it or something. You can't dispose of it, but you could certainly store it, and not have any duty to tell anyone. And actually telling the police that you have it would be a violation of your attorney-client privilege and would subject you to potential ethics violations and even up to disbarment. So with child pornography, however, since possession of child pornography is a strict liability crime, if someone came into you with a laptop full of child porn and says, here's my porn top, you got to hold on to it, you have to say no. You can't take it because your possession of it would be a crime. You're helping them to hold it for a time and return it to them would be conspiracy to commit a crime. It's a weird area, but you cannot take it. I think ethically what you just do is say no in that case. You don't, I don't think you have a duty to disclose it, but you should advise them to destroy it, or turn it over to appropriate authorities, and to stop possession of it immediately, because continued possession would be, of course, a crime. Can we see your bloody knife collection? No? Could someone potentially charge the cops with having child pornography? Strictly speaking, they possess it. Oh, wouldn't it be great? Wouldn't it be great if we could do that? But no. They have immunity from that type of stuff because they are acting in furtherance of their job duties. So it's like nuclear materials almost. Yes, that is aptly put, and you should treat it that way. You should keep as far away from it as possible. You should protect yourself from it in all circumstances and treat it as if you are going to lose your life being anywhere near it. That's legal advice for you about child pornography, is treat it as if it were the most toxic and dangerous substance in the world, because in a lot of ways it is, both on a moral and physical and legal level. So yeah, and TH3C0K3M4ST3R. Pedophiles out there, just become a cop. All the CP you can get. There's actually some merit to being either in that division of law enforcement or a content reviewer for Facebook or YouTube or something like that. The people who determine whether the offensive flagged content is offensive and should stay up or be taken down. And if you don't know, Facebook is now facing a lawsuit from damage from one of their employees who has alleged that they were emotionally distressed and damaged by being forced, as part of their job duties that they agreed to view offensive conduct at such a high rate as a content reviewer that they consume so much offensive content that it caused them mental damage. So I might be covering that lawsuit soon. It's kind of interesting, although I don't think they have much of a case. Corey Jamnick says, off-topic story. A handyman let a dog out off leash when the homeowner wasn't home, and it attacked my dog when I was walking him. Who do I go after for vet bills? The guy or the homeowner/insurance? Okay, so handyman let a dog off the leash when the homeowner wasn't home and attacked my dog. You go after, well, I'd say both and. The handyman will have professional liability insurance that you would want to consider going after. You also want to bring the homeowner and his insurance company into the suit. It would highly depend on the state statutes, and not knowing what state you're in, not asking you to dox yourself, and not knowing, even if whatever state you're in, I'm probably not going to know the specific dog bite law, although I do know a lawyer who could maybe help you out. But the homeowners, typically the dog owner is liable if the dog is if the victim is where they are legally allowed to be. The victim can be a dog. Let's be very clear on that. In civil suits, dogs are victims of dog bites, and damage to dogs is punishable and recoverable damages. Absolutely. So if the victim, being your dog, was where it was legally allowed to be and not provoking another dog, then yes, you should definitely sue the owner of the dog, their homeowner's insurance. I shouldn't say definitely sue. Let me rephrase that. You should talk to an attorney in your state about the validity of pursuing legal action against the homeowner, the insurance company, and the handyman and his professional liability insurance. Okay? I hope that clarifies things. I think the main responsibility under most statutes would be on the homeowner, and then the homeowner would have to recover any mitigating damages from the handyman who caused the action. But the homeowner, the dog owner, is typically the liable party there. So hopefully that helps. And yes, find a lawyer who specializes in dog bite law, although you know the one I would say not to go to. But dog bite law is actually a real thing, and it can be, the damages can be very high. Dogs are vicious creatures to other animals and potentially to humans, like babies and children, and damages can be horrific. So there's that. But all right, guys. Well, I think, unless there are any other questions, I'm actually going to wrap this video up. I've had a very long day. I'm not going to talk about that too much. But that is the defense for Cody Wilson. I hope that made some sense to you. I hope the idea in defending a case like this, and let me just reiterate the main points, you have to destroy the credibility of a girl who is 16 years old in this case. You have to do it largely, I think the best way to do it is to put her at odds with her friend, to put her at odds with her parents on stand, to illustrate that this is escalating behavior, to give the girl an excuse for the lie. See, this is the thing. Her lie can't be baseless and pointless, right? The lie has to have a reason for most people to think that a lie this big. Now, I'm not naive enough to think that people will not lie about just about anything. You just got to find the right person to make the big lie. People lie about big things all the time. But for a jury, you want to give the minor child the excuse to make a lie that they would identify with. You know, my relationship with my parents was becoming overbearing. I was lashing out. I wanted to hurt them. So I started going on this website. I went on a date with a guy and I lied about it. Now, you're not going to get her to admit that probably because this isn't television. You just want the jury to have this lingering suspicion in the back of their heads that the story that she went and had sex with this guy doesn't add up in this one way, in just enough way for them to say, you know, her relationship with her parents is spiraling out of control. She's lashing out. She's doing all this behavior. But, you know, we don't have any indication that she's like some slut actually sleeping around. We just know that she's engaging in this increasingly risky behavior, lashing out against her parents. It makes sense that maybe she would make up a big lie about this. And this guy does have a lot to lose. Why would he do this? Why would he engage in this activity? He was a former law student. If you don't know about Cody Wilson, he was a former law student. Now he's a CEO of a company that has pretty significant revenue and is massively in the news and has the potential to make a lot of money when all the lawsuits are settled. But he no longer does because he's now stepped down. So he had a lot to lose for this. So that's all got to be in there. So I hope that helps. I hope that makes some sense. Zephael, thanks for covering this. You're welcome. All right, guys. Thank you so much. I think I need to get some rest. Tomorrow. Let me stop recording this segment because this is going to be put up on the recording. All right. I'm still streaming. I'm just stopping the recording. Tomorrow, Friday's live stream will be with Doug Tenneple, the creator of Earthworm Jim. I was on his show on Wednesday morning. He is coming on my show. We will be talking about all sorts of topics, faith, family, politics, intellectual property, the creative process, being a self-employed individual, I guess. What all this stuff looks like. I don't know where the conversation will go. Come help us drive it. Come ask Doug questions about his time on VeggieTales, his time on Earthworm Jim, what he's doing right now. He's got an Indiegogo. We're going to talk about that probably. His affiliation with Comicsgate and his willingness to be an openly conservative Christian in the creative industry and what that's done to him. So, hopefully, that will be a fun stream. Please come check it out. Zephael, yes, please do sue yourself. Please do sue yourself. And I am not recording, but I am streaming. So everything still goes to YouTube. I'm just not recording the secondary, like basically the audio is what I was recording for the Cody Wilson stream. But yeah, unless you guys have anything else you want to talk about, I'm going to buzz out. I know someone mentioned Kavanaugh. I was on the postmortem for the kill stream. Kavanaugh vote for committee is tomorrow. Apparently, the Senate floor vote is set for Saturday. You want to hear me discuss Leviticus, or you want to hear me and Doug discuss Leviticus? That's the real question. Would there be a cause to sue yourself if you're trying to get insurance to pay up? In a weird way, yes. So how this would happen is if you know, you were injured, you or one of your family members were injured on your property and you needed homeowners insurance to pay for it, depending on the circumstances of the injury, you may have to, you're suing your insurance, but you're suing yourself for the liability that the insurance is supposed to cover. So that's kind of how you get there. That's the way. Ryan English says, thanks for the interesting stream. Go to bed. I am going to do that. All right, guys. Thank you so much. Talk to you tomorrow. You guys have a good night. Peace.